Well, thank you very much for coming here. And let me ask you at the outset, why did you decide to write this book now?
Well, it's interesting. That was a question that was posed to myself. I asked myself. Originally, I wanted to write about Sacramento, a small town in the 30s, 40s, 50s, 60s. My children grew up in Sacramento, but they didn't know about those earlier decades, and my grandchildren didn't know Sacramento at all. So it seemed to me interesting to me to write about that time in our culture. Our generation was right after the Great Generation,
right.
But we knew we could dream and we could build. In the small town, there was a courtesy, there was a professionalism that were simply wonderful. I wanted to write about that. Supreme Court, the first thing many people do is they forget about the Sacramento part. They want to read about the recent cases, so they look. But we wanted to have this for our children and our grandchildren to read. And then, as the writing went on, it seemed to me people were saying that it might be of interest to others. So that's the way it started.
So your children were involved in this, and other people. Do you have 5 to 4 decisions on whether to put this in the book or not put in the book, or no?
Well, as you know, as a writer, you have to condense. No, those decisions were made primarily by me, and the publisher indicated that we shouldn't have too many complex cases to talk about.
For those people that have not been a justice of the Supreme Court, and you were on the court for 30 years, what's the greatest thrill about being on the court, and what's the biggest downside to being on the court?
Well, perhaps the biggest thrill is that you have only cases in which the law has been undecided. And you recognize that what you're doing is exploring the law, and you know that after you write what the law is, or what you think it is, there's a whole new vista, a whole new realm to explore, and that's the fascinating part of it. We only take cases in which other courts have disagreed. In India, the Supreme Court has to take every case, and they have a 50,000 case backlog or something. But we select only the cases in which other courts have disagreed. And so that's the fascinating part, is that you are on the frontier of the law, and what you write is the beginning of a frontier because there's new things to explore.
All right, so the downside to being on the court is you can't talk to your wife ever about what you're doing?
That was true. We had a rule. My private practice in Sacramento, small town, my practice was a solo practitioner, and friends of ours who were quite prominent in the community had big firms for their lawyers, but they would come to me with special problems. So my rule was, Mary, never know who would come to the office. One time, someone came up to her at a party and said, "Oh, Tony did the nicest job helping us adopt our baby." And Mary said, "Oh, I hadn't heard." She said, "You mean he didn't tell you?" And she said, "He can never tell you what happens at the office." So we had that confidential rule, and it seemed to me quite improper for judges to talk about pending cases with other people, even their spouses.
So for 30 years, you couldn't ever talk to your wife about a case when you were working on it?
No.
Okay.
Mary would never know what I was working on, what the case was, whether I was writing a majority or dissent. She didn't even know what the case was, and she'd read about it in the newspaper. She said, "Oh, you decided that case?" I said, "Well, yes."
So when you're a justice of the court, can you go to a restaurant in Washington and people come up to you and tell you what they think about your cases, or people bother you about that?
It's interesting, David, that some of the people that do it are foreign ambassadors. They don't know the rules very well, and they want to be friendly. So they said, now tell us about this case, and here's what I think about this case you've just heard. And we changed the subject to what are you having for dinner or something like that.
So let's go back through your background for those who aren't familiar with it. You were born where?
Sacramento, California.
And your father was what, a lawyer?
My father was a solo practitioner and had an amazing law practice.
And your mother?
My mother had come to Sacramento, that's how she met him, from San Francisco in order to work for the state government, and she had been a teacher as well.
And do you have siblings? Did you have siblings?
Yes, I've lost them both, a brother and a sister. But we were a very close family, and we grew up together, and my sister was 2 years ahead of me at Stanford, and so I knew many of her friends.
So you're growing up, as a boy, were you interested in the law, or were you interested in baseball, or you interested in what? What were your interests as a boy?
Well, just a little bit of everything. We were interested in our family in government, and the book indicates that because I learned to read at a very early age. I was reading classic literature when I was 8 or 9 years old. And so I was a little bored in school, and my parents thought it would be a good idea for me to be a page boy, the only page boy at the state senate. So my mother had a teaching certificate. In those days, I don't think they knew the term homeschooling. But she went to the Department of Education, and they agreed that she would help me with whatever assignments we had, and I would spend many hours, many days at the state senate being their page boy.
So you must have done pretty well in high school. You got into Stanford. Was it hard to get into Stanford those days, or not that hard?
It was hard to pay for it.
But your father, was he a wealthy lawyer that could pay for all these things, or how did you finance college?
Well, I worked to help my father because my sister was there already, and we had other expenses. And so I worked. I did summer jobs to help.
Okay, so you decided to go to law school because your father had been a lawyer. Did he encourage you to be a lawyer, or you just wanted to be a lawyer?
Well, it seemed to be just natural. My first instinct was to be a doctor because one of my best friends was his father was a doctor, and if my friend who played on the football team was busy, the doctor would come by and I would drive him to his appointments at the house. In those days, they made house calls. And it was so fascinating to hear him talk. I was in the house sometimes, so he would have me with him with dying, very sick people. I thought I wanted to be a doctor, but I quickly realized I didn't have the physical capacity to do very well with my hands. My brother used to say I'm ambidextrous.
So Stanford has a good law school. My son went to Stanford Law School. Why wasn't Stanford Law School the one you went to? Why did you just choose to go all the way to the East at Harvard Law School? And had you ever been to the East before?
Well, because I knew, or thought I knew, that I'd spend my life in the West, so I wanted to see what the East was like. Because I had been in England for a year and was just fascinated with all the things I didn't know. And so that was one of the reasons I went to Harvard, because I felt certain that I would spend my life on the West Coast. As it turned out, that was wrong, but Harvard was a great choice. If you had a list of we'll make it up, the 10 finest law professors in the country, 6 or 8 of them would have been at Harvard. It was simply amazing. Stanford was also very, very good. But
Harvard Law School has a lot of lawyers that come to Wall Street and do something important like practice corporate law on Wall Street. And how come you decided not to do that, to go back west?
Well, it was important for me to go back home. Plus, my father was not well. It seemed to me important to help the family, and he wanted me to at least begin, even if I were practicing in San Francisco with a big firm. So because he didn't know how big firms worked. He didn't need to know. He was a very fine lawyer. But he wanted me to know what the structure of the legal profession was.
All right, so you joined the San Francisco law firm as an associate.
Yes.
And then you were there for a while, and you were helping your father a little bit from time to time. But then what happened that required you to really go back and live in Sacramento full time?
Well, my father, age 61, came and Mary cooked dinner for me. He visited us in San Francisco. It was interesting. This goes beyond the story a little bit. One of the things he said was, I'm very worried about President Kennedy. Jack Kennedy was the president of the United States at the time. He said, I don't think he's going to live out his term in office. And my father had that Irish prescience about him, and that was one of the last things he ever said to Mary and me. And we hugged and after her dinner, and then he died a few days afterwards.
So you decided to move back to Sacramento and take over his practice because you had a lot of clients who were looking for legal advice. And was it a tough decision to go back and become a one-person law firm again, what your father had done, or you could have stayed in San Francisco and worked your way up to the top of that San Francisco firm you were at?
Yes, that San Francisco firm now has offices all over the country, maybe all over the world. At that time, they had only 18 people. I look on the letterhead, I would have been way up. It was not so much that I took over my father's practice as it took over me. His clients said, now we're working on this, could you help? And most of my father's clients or many of them were friends of his and friends of the family. And it turned out that they thought that a younger person would be of an advantage, particularly state planning. I could carry on when something happened to them. So the practice more or less took over me, and the senior partner in San Francisco told me, he said, you're welcome here. He said, but you should stay where you are. You'll have an opportunity there that you wouldn't have here for many, many years.
Now, at that time, you had married your wife.
The beautiful Mary Davis, who's here. We've been married.
Married for how many years?
Well, I forget, 64.
64, okay, 64.
I'm still,
okay. And where did you meet your wife, Mary?
I'm still trying to get it right. Yeah.
Where did you meet your wife, Mary?
Mary was also from Sacramento. Our families knew each other. Mary's younger, and so we didn't date in high school because the 3.5 years is a pretty big thing. But we knew each other, and when I was in the Army and stationed at Fort Ord, it was exciting for them to give me a weekend off, and I was walking across this beautiful lawn in Carmel where my parents were going to meet me, and this beautiful girl came the other way, and it was Mary, and we knew we were in love. And there's a song, When You Were Sweet 16. I remember when first I met you on the village green. Mary wasn't quite 16, but the song still works.
Okay. So the result of that was you had 3 children, and how many grandchildren?
We lost my son.
Your son passed away. You had 3 children, 2 boys and a girl.
Right, and 9 grandchildren.
9. So you like the number 9, like on the court.
Right, right.
So you're practicing in Sacramento, and then somebody gets elected governor of California, and he asks for some advice. And that person's name was Ronald Reagan. So
Yes.
you got to know Ronald Reagan?
Yes, we first met before he was running for governor at some event in San Francisco. I was never part of the political world. But in Sacramento, a number of state officials would come to me, sometimes for private legal advice and so forth. And Reagan had some friends who were mutual friends, and we began to talk, and so we got to know each other. And Nancy knew. I said, "There's a few things you should never ask me." I said, one is about politics. I said, know about it the way most people know about it, but so far as all the insider things, you have, and he had one of the best political teams ever assembled. He had a marvelous person, Ed Meese and Mike Deaver in Sacramento, and Justin Dart and others in Los Angeles. He didn't need any advice from me. So I said, don't ask me about politics. And I said, second, don't ever ask me who should be appointed a judge. And he said, oh, that's where you can really help. And I said, well, maybe so and maybe no, but if you get, as a lawyer, and I had small cases, but I would go in the counties around Sacramento to appear in court. And if you get the reputation as a judge maker or a judge breaker, it's not good. The judge is going to either lean over towards you or lean maybe against you to show that he's fair. And so I just didn't want that. So I said, don't ever ask me who should be appointed a judge.
Did you ever show him your Reagan imitation?
No, I don't think so. But he had a wonderful sense of humor. And he asked me, he wanted to have a state California ballot proposal which would cut government spending. And so he asked me to draft the amendment. And I said, well, I don't know anything about budgets or bonds or special appropriations fund. He said, oh, this is an amendment to the Constitution, and you teach constitutional law. I said, no. That the constitutional law I teach has nothing to do with what you're talking about. He said, you mean you can't write something that we're spending too much money? Oh, I said, okay. So as it turned out, I told him that if he could, there were 2 or 3 very brilliant people that were acquaintances of mine, and it had come to my attention. There are many brilliant people. California, Sacramento had wonderful civil servants, David. They were remarkably competent and professional and quite brilliant. And so we put together a list of 5 or 6 people that could be on the drafting committee for this amendment. And when we first met, I said, now put your pencils down, put your papers down, just talk and tell me what you think we ought to do. And then I wrote notes. Oh, and Reagan wanted the thing in just a matter of months. I said, I can't do it that fast. But we had to do it. And so then we went around the state together to these editorial board luncheons in the Los Angeles Times, the San Francisco Chronicle, the San Diego Union. They would have the editors have lunch, and midway during the lunch, you didn't even wait for dessert, they would ask, and I would stand up and I said, I'm the author of this amendment and I will tell you what it means. And pretty soon Reagan got up and talked. He could absorb a briefing, David, better than any client I ever had. And he was just, and we traveled around the state together. One time, a young person held up the vulgar middle finger, and Reagan looked at me and said, all he needs is one more.
So ultimately that did not pass, but Reagan didn't get upset with you because he later called you and said Gerald Ford asked him for a recommendation to be on the Ninth Circuit Court of Appeals, and he recommended you, although you were only 38 years old.
Right.
So did you say, I'd love to be a federal judge even though the compensation is so low? Or do you say, I've got a family to support and I just can't do it?
Part of the problem with my practice, David, was taking me on travels because I had California clients who were establishing businesses in other parts of the country and other parts of the world. I was going to Eastern Europe, Asia, and the kids were growing up without me. I wanted to be home in Sacramento, so that was the reason. And Mary understood it would be a financial sacrifice, but the children and Mary have always been very, very supportive.
Right, so you took the job, you were confirmed easily, there was no controversy, you got on the court, and then a couple years later, Reagan is President of the United States.
Yes.
Did you ever think he would be President of the United States when you first met him?
Well, interesting. You don't usually think that about the people, but when his name started to surface, I thought, you know, there is a possibility here.
Okay, all right, so he gets to be President of the United States. He has a vacancy on the Supreme Court, and he calls you to be considered for it, and you come in for the interview.
Yes.
Initially, Robert Bork had been turned down for the position, so he then comes to you, and then it's between you and somebody else who he didn't know, and he gives it to somebody else. Did that make you mad?
No, I was delighted I could go home.
Okay. Well, that's somebody else who was my law school classmate, Doug Ginsburg.
Doug Ginsburg, who is, we've become good friends. He's a marvelous lawyer and a marvelous scholar.
He was a star in my law school class, a very talented person, but he had the sin of having smoked marijuana, apparently, at the time, and when he was a law professor, so he had to withdraw. So then Reagan calls you and says, come on back for an interview. Did you say, look, you didn't give it to me before, or I'll come back, but you really have to give it to me this time, or you knew you were going to get it when you came back?
No, I didn't know that, but one of the reasons Doug was appointed was because, he was never appointed or nominated, but one of the reasons he was considered was because he was with the Justice Department gang, and they wanted to show they couldn't be pushed around. But then, as you indicated, it didn't work, and Reagan asked if I could come back. I said, we don't know anybody in Washington. He said, oh, you know me. I said, what am I supposed to do, come for lunch every day?
So you come back, and he nominates you, and you get confirmed by 97-0.
Yes.
The last justice to be confirmed unanimously. So, okay. So you get on the court. When you get on the court, when you're the youngest person on the court, the newest member on the court, do they have a hazing thing for you, or what? Do you have to be in charge of the cafeteria or something like that?
Yes, you have to be in charge of the cafeteria, and we had the reputation of having the worst cafeteria on Capitol Hill. So it was an easy job to see if I could make it at least the second worst. And then when I left, Breyer became the junior justice, and he was junior justice for 11 years, David. And when finally someone else came to the court, it was Alito, Breyer became second junior. So Scalia and I made the motion that the cafeteria duties should go to the second junior justice.
So you mentioned 11 years. This is, I think, the only time in the Supreme Court's history where you had the same 9 justices for 11 years.
Yes.
So you worked together with these same people for 11 years. Did you get tired of seeing them every day, or not really?
Just the opposite. It would be, we were together so long, you knew what I knew, that you knew what I knew you were going to say, and we could more or less begin from there. And we knew sometimes we wanted to really work hard to convince each other, which we sometimes did in conference. You didn't always go into conference knowing exactly how the case should come out. And there are different ways to decide a case. Sometimes you find an issue that you think should resolve the case that hasn't been fully discussed by the lawyers
So for those people that aren't familiar, how you decide, let's go through the process. You have people who want to appeal to the Supreme Court. They have something called a writ of certiorari, and you accept you have to have 4 justices agree to accept
it's called the rule of 4. You need four justices to grant a petition for certiorari. Petition for certiorari is a motion to please take our case. And the court has thousands of petitions of certiorari each year, but they select only those cases where the courts are in conflict and where we think the guidance of the court will be helpful.
All right, so you can take about 70 or so of the cases a year, something like 70, 75, something like that a year. When the cases are taken, the briefs are submitted by the lawyers. Do you talk to each other, the justices, before you actually hear oral arguments, or you just read the briefs and then you go to the oral argument and you don't talk to each other before you actually hear the oral argument?
We're very careful not to talk to each other before, in part just in fairness to the lawyers, and we don't want cliques where you and I agree or you and I disagree, and I don't tell you what I've talked to the other judge. We don't do that. We do talk to our law clerks about it. We each have 4 law clerks when you're active. And we talk, in my chambers, my instruction was that the clerks would take different sides and they would argue different sides of the case and we'd argue about it. And it was fascinating, and we would prepare for argument that way, but without talking to the other justices. Occasionally, it would seem to me that there was a technical problem in the case that the lawyers had missed, and I might go into Steve Breyer, who had his chambers next to mine, and say, it seems to me this is a problem we talk about. We'd immediately send a memo to the rest of our colleagues that Stephen has been talking with me about what problem we see in this case, and we think that. So we were very, very careful, and the justices were always very careful, that if they did have just a quiet conversation, they would immediately notify the others what it was by a memo.
Okay, so you hear the oral arguments. Are the lawyers sometimes really good and really compelling, and they convince you to change your mind, or they really aren't that great and you never change your mind based on the oral argument?
In the Supreme Court, you're very lucky because they have, by the time it gets to us, excellent counsel. Many of whom have argued with us, have argued before. And if you're an attorney, there's the argument you plan to give, the argument you did give, and the argument you wish you'd given when it was all over. And so the oral argument can be very, very tense, and the lawyers can be very nervous. We were never nervous when I went on the bench. I went on the bench just like I'm here with you, enjoying myself. But when I went into the conference room with just the 9 of us, then I'd be nervous because I'd have to talk about the case.
So the arguments are completed. You then have a conference. You do it once a week or something like that?
Well, just getting back to the arguments for a minute because I didn't answer your question, excuse me. The arguments are when we begin to learn what our other colleagues are thinking about the case. And we ask questions of the lawyers. My questions were usually on the side that I thought should probably prevail because I just wanted to test their case. I didn't argue with the other side to show that they were wrong. Plus the fact the cases are so close that we would change our mind based on what we heard and what our colleagues were saying. It's a very real dynamic, or was when I was there.
Some people say that the justices ask questions not to get answers, but to influence their colleagues about the case. Is that?
Yes, if you and I are colleagues and the lawyer's out here, I'm using the colleague, or the lawyer actually to talk to you.
Okay. All right, so after you hear the oral arguments, you go back to a conference, and you have a airtight room so nobody can listen to what you're saying, and so forth, and nobody is allowed in the room other than the justices?
Right, and we have a double door just to remind everybody that what goes on in there is absolutely private forever.
Right. So then you begin to say what your views are, and who decides to speak first? Who gets to speak first and who speaks last?
The Chief Justice speaks first. The next most senior justice, senior because he or she has been there the longest. Seniority is not by age, but how long you've been around. And so you begin with the Chief Justice, and then you go from the most senior to the most junior. If you're the most junior, and it's 4-4, it's very exciting because everybody is listening to what you're going to say. So you can drag it out a little, have a little suspense.
So who decides who writes the opinions? Who decides that?
Let's assume there's a majority
Right.
and a dissent. Sometimes they're unanimous. There are a lot more unanimous opinions than most people think. But the senior justice in the majority assigns the majority, and the senior justice in the dissent assigns the dissent.
Right. and then the opinion process has begun, and then the justices circulate their drafts to other justices to get comments or to persuade them to change their vote, perhaps? How does that work?
All of the above. Well, to begin with, you start to write. And many of you have written a letter or a memo to your office colleagues, and you start writing it on a computer screen or on a piece of paper. And the first draft doesn't make a lot of sense, even if you're maybe writing a letter to a friend. So you put that in the wastebasket, and then you write a second time. And that's the process.
So does any justice ever go down to another justice's chambers and say, you know what, I really don't like your opinion, but I'll support you if you support me on another case? Do you ever do that kind of horse trading?
No, that would be totally improper. Might even be illegal. You never trade votes, ever.
Nothing improper or illegal in Washington will ever happen, right?
Ever. So. Plus the fact that we don't go to the other chambers. We send it by memo. We call each other by names. And so a memo would come from me to John Stephen. Dear John, your opinion reflects my vote at conference, but it seems to me that you are spending putting too much emphasis on point 1 when it should be point 3. So but everybody gets a copy of that memo. Everybody gets a copy of the memo.
So the justices read the memos. They may change their mind and the opinions, but more times when you were on the court, you were the 5-4 in the majority than anybody else, I think.
I think that's right. Yeah.
So when you're 5-4 in the majority and you're making the real decisions because you're the deciding vote, does that put a special burden on you to really make sure you're comfortable with the decision?
Well, it seems to me you always have, as I indicated earlier, you want to make sure that what you say makes sense for the law and for the precedents and for the justices and for fairness to the parties and to reach a decent common sense result. So you're always thinking about that, and you want the views of your other colleagues to indicate that you're going in the right direction or the wrong direction, and there's a lot of interchange in the memos that way, and that's how we try to put a majority together. Sometimes you're assigned the majority opinion, and you'll get a memo, Dear Tony, I've read your draft opinion. It seems to me better to wait to read the dissent. You say, oh, what's going to go on? Or sometimes you write a dissent and say, on the other way around, you convince other people.
So then the justices, when the opinions are ready, the justices then announce them in front of everybody publicly. Is that how it's announced? But in the old days, they used to read the entire opinion. You don't do that anymore.
No, they didn't have to. But of course, on workload, our workload has changed. During my time on the court, we had close to 150 cases a year. Now they have half that, 75. They have many emergency motions. We had a lot of more emergency motion and death penalty. We had much more death penalty cases those days where you get a call in the middle of the night and you'd have to.
So each justice gets 4 clerks. They're all young Supreme Court qualified people in terms of the top of their class in law schools and so forth.
Yes.
How did you pick your clerks? Did you ever pick any you said, oops, I made a mistake, I shouldn't pick this person?
No. The people that apply to you have wonderful resumes, and they're toward the top of their class, and they've usually clerked with a Court of Appeals judge or a district court judge. It was important for me often to try to hire clerks who've been with a district court. District courts, in a way, a United States district court is the best job in the world. You're the only judge, you run your own empire. And the trial judge gets to see real people. He gets to see jurors and witnesses and attorneys. On the Court of Appeal, we don't have. If you ever go to England, you'll spend money to go see a show on the West Side or West End or something. Go to the Old Bailey. Number 1, it's free. Number 2, it's the best show in London. the lawyers, David, are simply marvelous. And they spend a lot of time with the judges. I was there, we were there not too long ago, and the judge said, "You've been going on for some time now, and I'm no wiser than I was before." And the barrister said, "Sadly, no wiser, my lord, but perhaps better informed."
You've had...
And in the law we have what we call maxims of statutory construction, but they can cancel each other out. You can cite one side or the other, like haste makes waste, and a stitch in time saves nine. And so we were there one time and listening to the argument, and the judge said, "If counsel begins to quote the maxims of statutory construction, I shall be forced to leave the room." And the lawyer said, "Oh, my lord, I would not wish to precipitate such a calamitous event." So they go on like that. But being a trial judge in England or the United States is, I think, maybe the best job in the world.
You've had more than 200 people serve as your clerks, and 2 of them are now on the court.
Yes.
And I think no other justice actually had 2 of his or her clerks become justices themselves.
That is true.
Were you surprised that these clerks of yours later became justices?
No, they're both brilliant, wonderful people, and I wish all my clerks were on the Supreme Court.
One of them, you served with one of them when he was on the court. Justice Gorsuch was on the court while you were still on the court.
Yes.
And so what's it like being on the court with somebody who used to be your clerk and did anything you wanted to do, and now he has his own independent view? Was that hard?
I told him, "You didn't do what I told you when you were my clerk, you will now." No, it was wonderful. Yeah.
Let's go through some of the more consequential cases. You wrote, hundreds of opinions, and there are many that we could go through, but let's go through just a couple we have time for. Let's talk about Bush v. Gore. You wrote the per curiam opinion, which meant that it's for the whole court. You didn't put your name on it. Was that a very difficult decision for the court to get involved in the case and then make the decision that would decide the election?
Not a difficult decision at all. 7 of us agreed with you to take it. Can you have a state court decide who's going to be the president of the United States and say, "Well, we're too busy to take it"? Incidentally, the book explains the opinion began as Gore versus Bush. Gore bought the case, not Bush. Gore bought the case, and he prevailed in the lower courts. And the rule is that if you're unsuccessful in the lower court and you come to the Supreme Court, you're the so-called petitioner, and your name is first. So it was Bush who brought the case to the Supreme Court, so it was called Bush versus Gore. But Gore was the one who started the case. 7 of us agreed that we should take the case. And more than a majority, 6 or 7, agreed that there was a legal wrong. The question was how to remedy the legal wrong.
In that case,
and that was 5-4.
Ultimately 5-4. The 5 people who were for Bush were Republican appointees. The 4 who were for Gore were the Democratic appointees. Some people said that showed the court was really political. How do you respond to that?
No, to begin with, that's wrong. Souter and Stevens were both Republican appointees.
Okay. All right, so you don't think the court was hurt by the perception that it was a political decision?
Yeah, the court's always hurt, it seems to me, if we look political. One of my concerns, my present day concerns, is there's too much partisanship. Judges, the Senate pays too much attention to the fact that you're a Republican or a Democrat. It's true historically that most presidents have appointed justices to the Supreme Court who are members of their own party. Eisenhower didn't. Eisenhower appointed Brennan, who was a Democrat, and he appointed Earl Warren, who was an independent. But it is true that historically, and there's some other examples, Byron White's another. It is true that historically, I may be wrong about why do I think about that. The presidents appoint justices from their same party, but the partisanship should not be an overriding factor. What you look at is temperament, learning, background, reputation, whether or not you have those qualities of independence and caution that make for a good judge. And the partisanship is overemphasized in the Congress in the Senate during the nomination process. They should not emphasize it so much.
So you will be always remembered for, among other things, the decision you wrote to legalize gay marriage.
Yes.
And was that a difficult decision for you to come to? And have you found any reason why people are upset about that? Or do you think the court will ever reverse that decision?
Of course people are upset about it. And it was a very difficult decision. When we were growing up, the gay movement was just something we just didn't know much about or to think much about. And the gay marriage, we with my clerks, we spent days researching the history of marriage, reading the Bible, and great works of jurisprudence before the Christian era. And other than the island of Lesbos, of which we don't know much, there was no indication that marriage might be between people of the same sexes. It was true, we did find out that the nature of marriage, David, changed greatly. In the United States, until after the Second World War, in many states it was unlawful for people of different races to be married. And also the status of the wife changed greatly. It used to be the husband basically owned the wife. If there was all the property was his. If there was a divorce or a separation, he would have custody of the children. And so the nature of marriage, the nature of the other spouse changed greatly over time. And for me, the important and perhaps deciding factor was the children. We were amazed to find that at first it looked like 75,000 children were adopted by gay parents, and then it turned out they were in the hundreds of thousands. And these children were in states that did not allow gay marriage at a disadvantage, and the parents were at a disadvantage. If the child was sick, only the adopting parent, not the spouse, could come to see the child in the hospital. And the kids would have to say they don't have to have two parents. And the stigma and the hardship on the children was a very important factor for those of us in the majority.
When you wrote your opinion, there was a dissent by Justice Scalia.
Yes.
That was fairly personal and very vituperative, some people would say. And later, he came to you, you write in the book, and sort of apologized for the tone of that. Is that fair to say?
That's a good summary of it. The vituperative is a good adjective. The dissent was much more personal, of a personal attack than you see on the court. And it made Nino himself unhappy. He decided he wasn't coming to our lunches. He wasn't talking even to the other colleagues. He felt very much alone. And later came to regret what he wrote. And the book indicates that he wanted to see me in chambers, and he came. And we discussed it. The opinion had indicated that California doesn't count as part of the West. And it was important for me to tell him that I'd worked in the oil fields. I'd worked in Montana. I'd worked in the oil fields in California. My uncle was in the oil business and was very lonely because he'd been in World War II and just didn't feel he wanted to be married. So he was a very handsome man, but so he had me come and work in the oil fields with him from the time I was 14 or 15. And I worked all over the West, and I helped harvest asparagus on Sacramento ranches, and and I was a guide for a riding stable at Lake Tahoe, where they had horseback riding. And if they didn't have a regular guy, they asked me to take this. So I felt that I knew the West. And Scalia began to understand that, and he came by and he apologized. And the book says we're not either of us big on hugging, but we gave a little hug to each other. And I said, Nino, take care of yourself. You're working too hard, traveling too much. And he was on his way to Texas. I think it was Texas. Yes. And he said, Tony, this is my last long trip. And those were the final words he ever spoke to me. He died a week later. But he came home. A Marine, they lived just a block and a half away from us. And Marine immediately came over when she heard about the news to have us help her. And she told me that after that meeting, he came home. She said he was happier than he'd been in months. So that shows you that if you sometimes admit the fact you overstepped, you're a happier person.
So you have been concerned about civility generally in life, and you think civil discourse is an important thing in our country. Increasingly, you see dissenting opinions in the Supreme Court aren't quite as civil as maybe you might prefer. And is that of concern to you? You're not on the court now, but is it a concern that sometimes the justices are very uncomplimentary of each other's views?
Yes, it's of great concern to me that our civil discourse, our civic discourse, is not civil enough. Aristotle said that a democracy depends on an open debate where you respect the dignity of those with whom you disagree. Aristotle said that, and he said democracies can die. He said democracies only live if they are sustained over a period of time by a thoughtful, rational discourse, a discourse in which you respect the dignity of those with whom you disagree. And I think that's a danger in our present day and age. What do they call it? Political identity. If you're a member of party X, then we just assume you have all these views and we don't like you or we do like you. This is not good for our public and for our national discourse. And we have to remember, David, the rest of the world looks at the United States to see how democracy works. And we have the duty to show them that our public dialogue is decent, respectful, thoughtful, rational. Many countries, you go, you say, oh, we're giving you free speech. They don't want it. They would prefer a system in which there is more order, not necessarily on the communist model where they tell you what to think. But we have to make the case for free speech, and I'm afraid that ultimately, I think our young people and all of us will realize the importance of a more respectful discourse. I'm optimistic in the long run. I'm concerned in the short run.
Now, you are a very devout Catholic, and therefore the abortion decisions that you've had to rule on have been very complicated for you. And you pointed out in your book that at one point you thought of actually resigning from the court rather than having to deal with the abortion issue. How did you come to the decision, in light of your religion, that you could support abortion more or less in the cases that came before you?
Well, the abortion that we did, and there are 4 others agree with me, was a right to choose only very early in the pregnancy. But in the first weeks of the pregnancy, first few months of the pregnancy. So it was limited to that, and in our family we would never have had an abortion. And my mother in Sacramento was in charge, and our family helped establish a home for unwed mothers, where they would have the child, and hopefully keep the child, or if not, would be adopted. And it seemed to me, perhaps it's wrong, but I don't think I heard the term abortion until I was late in high school or in college. It was just not something that was part of us. And as Catholic, we believe that from the very moment when the embryo first begins to grow, he or she has a voice, and that voice says, "Let me live, let me live."
So let me ask you.
And I had to put that to one side and say that in an open society, what we do is we go out and we try to convince people not to have the abortion ever. We have that duty to convince them, and we can do that.
What would you like people to most know about the court that you think they don't know? Right now people sometimes have a view the court's political or whatever it might be. What would you like people to know about the court, and they might get by reading your book that they might not already know?
I think they should know more precisely how collegial it really is. We know that if you and I are justices together, we know we would disagree. We're supposed to disagree. That's our job. But the question is how we disagree, and the interaction on the court is much more fascinating than most people know. You hear things that you had not thought of before, and you see new possibilities for the law, because after you decide something, there's a whole new realm for which to explore the future. And these are the things we talk about, and we've been very fortunate over the years to have justices who have very, very fine educational and legal background. It was my privilege to serve with 17 different justices. There's only been, about 110 in our history.
So your book is called Life, Law, and Liberty, and I enjoyed reading it, certainly, but I want to ask you a final question.
You stayed awake? Well, that's good.
It is said by some that if you see the word liberty in an opinion, you know it's written by Justice Kennedy. Why is liberty such an important thing to you?
When the authors of the Constitution sat down for a period of, 3 months in Philadelphia, if they had known all of the details of what freedom means, they would have put it down. But they were modest enough, they were thoughtful enough to know that the components of freedom, the components of liberty, are something we must learn over time. So they use spacious words like life, liberty, and property. Incidentally, lawyers even sometimes make the mistake, we think of life, liberty, and happiness. That's the Declaration of Independence. The Constitution talks about life, liberty, and property. Why doesn't the Constitution talk about happiness? Because that's judicially unenforceable. Although perhaps some judges would be ready to try. But
And you always carry a copy of the Constitution with you everywhere you go?
well, usually I do, because it's interesting. This is both the Constitution and the Declaration of Independence. If you read the Constitution of the United States, sit down cover to cover, it'll take you about 2.5 hours and you'll fall asleep for part of it. The preamble, the preface is simply beautiful. And you can read that when you go home tonight. It's one sentence with semicolons. And it begins with the same words in it. We, the people of the United States, in order to form a more perfect union and so forth. And then at the end it says, do ordain this Constitution of the United States. It ends with the same word that it begins. Fascinating, but beautifully written. But the rest of it, and there's some beautiful phrases in it. Now, the Declaration of Independence, you can read in, 15 minutes. The more you read it, the madder you get at King George. So those are the two different documents. But the Constitution, it's fascinating that has lasted we have the 250th anniversary of the Declaration of Independence next year, and we're going to have a time capsule that people will open 250 years from now. If we put the Constitution of the United States in the time capsule 250 years from now, will it still be known? Will it still be respected? Will it still be the way in which our nation defines ourselves? It has been for the last 250 years. Did Washington, Madison, Hamilton think that the Constitution they drew would last 250 years? We were talking, Jefferson thought it would be amended all the time.
I probably won't be here to find out, but look, I want to thank you on behalf of the American people for your commitment to the country, the Constitution, and your 38 years of service in the Supreme Court. And thank you for this book, which explains a lot about your life.
Oh, well, thank you.